Good morning everyone and welcome to the 2023 Myerson Annual Property Update. It's lovely to have you all with us. I do hope you find this morning's webinar interesting and informative. As I'm sure you're all aware, high inflation and increasing interest rates have continued to make conditions very difficult for the real estate sector in the last 12 months. The fallout from the mini-budget a year ago now is still having a profound effect on the market. It was the final straw really for a market already struggling post-Brexit and dealing with the war in the Ukraine and the global energy crisis. The big news this week, of course, is what's happening in Manchester at the Conservative Party conference and the political furore surrounding the cancellation of the HS2 Birmingham to Manchester leg. It's obviously a hugely emotive issue on many fronts, but it remains to be seen what effect it will have on the proposed levelling up of the country and what's going to be proposed in its place to support the development of the North. Reports from the big agencies are that transaction volume, particularly in the capital markets sector, has been much lower than usual over the past 12 months. There are signs, however, that a recovery could be on the cards over the coming months. Perhaps slower than we would all like, but it will happen. The market will have to come back at some point. These things are always cyclical. Anecdotally, the market is becoming busier now, with surveyors seeing deals start to happen, and more importantly, happen more quickly. One feature of the market over the last 12 months has been the frustratingly slow nature of every transaction, where something which would normally take a couple of months is routinely taking perhaps 4 or 5, even 6 months to get over the line. With a number of renegotiations, changes of heads of terms, and perhaps changes of heart also during that period. The market and our clients are telling us that things are being done now, still a bit slowly and carefully, but the fact they're being done is reason enough to be optimistic. On another positive note, energy prices aren't quite where they were last autumn and winter. Whilst they are predicted to rise quite sharply again over winter this year, there's no sign at the moment that they'll have the destructive effect on the economy they had a year ago. With the government rejecting M&S's bid to demolish and rebuild its Oxford Street headquarters, the retrofit versus rebuild debate rages on. Real estate's role in carbon emissions is well documented, and many in the sector are committed to delivering net zero projects going forward. Some investors are actively targeting assets with poor environmental performance to get what's effectively a distressed asset at a good price, so they can be upgraded and future-proofed to meet high environmental standards. Not only do they hope to make a good return on their investment, but arguably it's also the greenest investment decision they could make. There is still a lot of change happening in what offices mean to businesses, and they and their landlords are going to be working that out for the foreseeable future. What kind of office space do they need and what will it need to offer to be attractive to workers? The construction sector, it's also still behind where it had aimed to be, principally due to scaled-back residential development projects in the housing and residential investment markets and hugely increased costs of materials. So all in all, there are still quite a few uncertainties around, which are going to affect confidence for some time. Interest rates have hopefully peaked and inflation is starting to reduce. Hopefully this means we can get to a position where prices of assets stabilise and the market gets moving. Business hates uncertainty, and until there's some certainty and stability about the future of the economy, we're unlikely to see things fully recover. Now we're throwing HS2 into the mix, things may continue to be difficult for some time to come. So back to today. We want to focus on various topical subjects as well as bring you up to date on the latest developments in case law over the last 12 months. The Building Safety Act, it continues to be something which occupies the minds of a lot of people in government and the property world, and it'll continue to do so for the foreseeable future. The regulation flowing from the Act is wide and ever-growing as the government seeks to ensure that safety concerns for occupants of high-rise buildings and also other properties are fully and comprehensively assessed. Karen Taylor will talk us through the current position there. ESG issues are obviously increasingly at the forefront of everyone's minds, and we've talked quite a lot about the impact of the built environment in our webinars over the past 18 months or so. The government has recently made a bit of a U-turn on the timetable for commitments to reaching net zero and on its climate change strategy generally. Amongst other things, the relaxation of energy efficiency standards for homes is a significant policy shift, but the environment is an area where regulation is going to have to continue to develop quickly. So Emily Sutherland will be focusing today on biodiversity net gain. That's a conservation approach which requires developers to positively affect the biodiversity of an area as a result of their projects, rather than just to mitigate any damage that might be caused to the environment. The government announced last week that developers in England will be required to deliver 10% biodiversity net gain from January 2024 onwards. The legislation and regulation will be announced by November this year. The press release hailed this as setting out the next steps for requiring new housing, commercial and infrastructure developments to be nature positive. But this actually only told part of the story. The position was actually supposed to be that not only would they announce the regulation, but that it would actually come into force in November. Emily will tell us more about what's to come over the coming months. We'll then hear from Laura Pyle. Laura will take us through the most important cases of the last 12 months in the property sphere. I'll then take back the microphone to talk very briefly about property insolvency in 2023 and to give you a look at our exciting new Myerson Property portal. So firstly, I'd like to hand over to Karen.
Good morning, everyone. Today I'm going to run through the latest developments under the Building Safety Act 2022. The Building Safety Act has been described in the Commercial Property Standard Inquiries as one of the most far-reaching pieces of real estate legislation this century. It's therefore essential for property professionals to be aware of the practical implications arising from the Act and the secondary legislation which has been and continues to be implemented since the primary legislation was passed. I'm going to first give a brief recap on the current position and then look at the deadlines imposed by the Act, which came into effect earlier this month. The Act was introduced to address the safety concerns for occupants of high-rise buildings after the 2017 Grenfell Tower tragedy. It's intended to improve the design, construction and management of high-risk buildings, or HRBs, and received royal assent on the 28th of April 2022. It is worth bearing in mind that whilst the focus of the Act is on HRBs, there are provisions in the Act that apply to all properties, regardless of their height or use. However, today I'll primarily focus on some key developments relating to Part 2 of the Act, dealing with building control, gateways and duty holders, and Part 3, dealing with accountable persons, registration and the golden thread. So, by way of recap, HRBs are defined for the purposes of Part 3 of the Act as high-rise residential buildings, hospitals and care homes that are at least 18 metres or 7 stories high. Whilst there needs to be a residential element to qualify as an HRB, there's no requirement for buildings to be solely residential, and therefore the Act applies to mixed-use assets. The Act stipulates how information about a building must be maintained for someone to understand how to keep that building safe and how that information must be managed. This is known as the golden thread. During the design and construction phase of the building, those with duty holder roles, such as designers and contractors, will have responsibility for the golden thread. During the occupation phase of the building, the responsibility for maintaining the golden thread passes to the accountable person, a person responsible for ensuring that fire and structural safety is properly managed for the building. The Act also provides for 3 gateway points for new HRBs which must be complied with before the development proceeds. The first gateway, the planning gateway, came into effect on 1st of August 2021. This requires certain applications for planning permission to include a fire safety statement and for the Health and Safety Executive to be a statutory consultee. There's been a consultation in relation to gateways 2 and 3, and the response to the consultation gives the industry more certainty as to the detail of the new gateway regime for HRBs and the duty holder regime. The provisions have been implemented by new regulations. Firstly, the Building Higher Risk Buildings Procedures England Regulations 2023, and secondly, the Buildings Regulations Amendment England Regulations 2023. I'll now look at how these new regulations give further clarity on how the gateways will operate and the deadlines that industry professionals must ensure they have complied with. So moving on to the gateways, how do the regulations stipulate that the gateways will operate? For completeness, it's worth reviewing Gateway 1, being the planning gateway. This requires those seeking planning permission for a higher risk building to submit a fire safety statement for approval as part of the planning process. This gateway has been in force since 1st of August 2021. Gateway 2 is the pre-construction gateway. The regulations provide that an application must be submitted electronically to the Building Safety Regulator, the BSR, with supporting documentation. Applicants will have to demonstrate in their application how their proposals comply with building regulations. The BSR will then have 12 weeks to consider and either accept, give conditional approval or reject the application. There will be a stop-go point. So if a developer is unable to demonstrate compliance, it will not be able to proceed with construction. It will be an offence to commence work before the BSR has given Gateway 2 approval. If approval is given, the BSR will operate a bespoke inspection and enforcement regime for the works. A notice of commencement must be given by the applicant at least 5 working days before it commences construction. Any movement from the original proposals during construction must be approved by the BSR before being undertaken. So next, turning to Gateway 3. The applicant must give notice that works are complete to the BSR. The applicant will need to then submit an application electronically to the BSR with certain required information. The application must be submitted by the principal accountable person. As mentioned earlier, the accountable person is an organisation or individual which owns or has a legal obligation to repair any common parts of the building. This may be the freeholders, a landlord or managing agent, or other person or organisation. A condition of Gateway 3 approval will be for the applicant to provide a statement confirming that the golden thread has been handed over. There are then 2 conditions that must be satisfied before the residential elements of a new HRB can be occupied. Firstly, a building's regulation completion certificate must have been issued by the BSR. The BSR has 12 weeks from the date of the Gateway 3 application, which I've just mentioned, to approve and issue a completion certificate, agree an extension of time for the information, or reject the application. Secondly, the HRB must be registered with the BSR. A completion certificate will be required to do this. It will be a criminal offence to allow residents to occupy a building that has not been registered, meaning that there's a risk of a fine and/or imprisonment if the regulation is not complied with. Gateways 2 and 3 came into force from 1st of October 2023. Therefore, 30th of September 2023 was the deadline for submitting an application to register any qualifying high-risk buildings that are used for any residential purposes, including as part of a mixed-use regime. From 1st of October 2023, existing high-risk buildings will also need to have been registered with the Building Safety Regulator. Next, I'm going to look at ongoing responsibilities. Clearly, the regulation of HRBs does not end once the registration is completed. Ongoing responsibilities of an accountable person once the HRB has been registered include applying for a building assessment certificate if one's required, displaying notices and certificates in the HRB, continuing to assess and report, maintaining up-to-date information, and managing residents' requests for information and complaints. Building assessment certificates will be one of the main ways that the BSR will review compliance with the obligations. Those provisions aren't yet fully in force and they're yet to be finalised. However, it is expected that within 21 days of a request from the BSR, the principal accountable person will be required to apply for a building assessment certificate and supply certain information, such as a recent safety case report. Assuming that the BSR is satisfied that there's been full compliance, it will issue a building safety certificate that the principal accountable person will have to display prominently in the building. It is anticipated that the BSR will undertake the initial building assessment certificate reviews for existing occupied HRBs over a 5-year period from full implementation of the relevant provisions. Undoubtedly, the management of and compliance with these obligations involves potentially significant time and cost expenditure for the freeholders, landlords, or managing agent with ongoing responsibilities of being an accountable person. A question that's no doubt going to be asked is whether the costs of compliance, such as preparing safety case reports, can be recovered as service charge. Section 112 of the Act introduces implied terms in long leases of more than 7 years of dwellings in HRBs. It ensures that there's a contractual provision in the lease which requires both landlords and tenants to comply with statutory duties. It also provides for the recovery of such costs where long leases contain variable service charges. There are various exceptions to the costs which can be recovered, including costs of the works to the building, any penalty imposed by the regulator, or costs incurred by reason of negligence or breach of contract. There will need to be a consultation under Section 20 of the Landlord and Tenant Act 1985 if the landlord enters into a qualifying long-term agreement for more than 12 months with a service provider, and where the leaseholder will be required to pay more than £100 per year per property. Leaseholders will retain the ability to challenge reasonableness of the costs incurred by way of an application to the first tier tribunal. So, bearing all this in mind, what are the main practical points which property professionals should be aware of? Firstly, the need to clear Gateway 3 before residential occupation can commence is a major change. This change will need to be factored into any handover provisions and/or the definition of practical completion for HRBs. Commercial occupiers may also require similar rights, that they are not required to take up occupation until Gateway 3 is satisfied. The hard stops will need to be accommodated by the construction development timetable. And importantly, the regulations cover existing HRBs in addition to those in the process of being constructed. If they haven't already done so, property owners should therefore ensure that they review their portfolios to check whether they include existing HRBs. If they do include an HRB, they need to identify the principal accountable person, determine who will submit the application to register, collate the information, and ensure that existing HRBs have been registered by the 30th of September 2023. Landlords should look at those costs which have been recovered from leaseholders and assess whether a Section 20 consultation procedure is required. They should also make sure that compliance costs are accounted for so that they can be separately identified. And they should also take care that costs are reasonable to ensure that challenges are minimised. It remains to be seen how the FTT will deal with future challenges on the recovery of building safety compliance costs. And that concludes my brief run through the key statutory deadlines for compliance with the Act, which came into effect earlier this month. Thank you.
Thanks, Karen. Lots to think about there. So now I'd like to hand over to Emily, who is going to talk to us about biodiversity net gain requirements.
Good morning, everyone. The global real estate landscape is undergoing a transformative shift driven by environmental, social and governance considerations. Among the many ESG issues, biodiversity net gain requirements have emerged as a significant focal point, urging property developers to rethink their approach to construction and land use. In a groundbreaking move to harmonise economic growth with environmental preservation, the UK government has introduced a mandatory biodiversity net gain requirement for new housing and commercial developments in England. Under the provisions of the Environment Act 2021, this pioneering initiative seeks to revolutionise the way development projects impact our natural ecosystems and ensure a sustainable and resilient future for all. In this part of the webinar, we delve into the world of ESG in property, focusing on the implications of biodiversity net gain requirements for developers and providing insights into how they can comply with these new obligations. Biodiversity Net Gain is a forward-thinking conservation approach that seeks to enhance the overall biodiversity in a given area as a result of development projects. Instead of merely mitigating the negative impacts of development on the environment, Biodiversity Net Gain focuses on achieving a quantifiable increase in biodiversity. This is achieved by ensuring that the ecological value of an area after development is higher than its value before the project began. On the 27th of September, the government set out the next step on plans for new housing, commercial and infrastructure developments to be nature positive by confirming that upcoming legislation to bring in these rules will be laid in November this year. Biodiversity Net Gain requirements involve several key components that collectively aims to ensure that development projects have a positive impact on biodiversity and ecological systems. I will discuss these key components over the next few slides. To implement Biodiversity Net Gain effectively, developers must conduct a thorough baseline assessment of the site's existing biodiversity. This assessment serves as a reference point against which the post-development biodiversity will be measured. The Biodiversity Gain provisions in the Environment Act provide that every planning permission in England is deemed to be granted subject to a condition that the development cannot begin until the developer has submitted a biodiversity gain plan to the local authority and the local planning authority has approved the plan. The purpose of the deemed condition is to ensure that the biodiversity gain objective is met. The biodiversity gain plan that the developer is to submit must include: firstly, information on the steps taken or to be taken to minimise the adverse effect of the development on the biodiversity of the on-site habitat or any other habitat. Secondly, the pre-development and post-development biodiversity values of the on-site habitat. Thirdly, any registered off-site biodiversity gain allocated to the development. And finally, any biodiversity credits purchased for the development. Mandatory biodiversity net gain will only apply to new planning applications for planning permission for major developments made after November 2023. The implementation of biodiversity net gain hinges on accurate assessment. A standardised biodiversity metric is employed to gauge the biodiversity value of a site before and after development. The metric uses habitats as a proxy for biodiversity value. It does not address impacts on species, nor recognise the significance of site designations or take account of indirect impacts, cumulative impacts, or in combination impacts. By comparing the pre-development baseline and post-development scenario, the metric can therefore assess how a development will impact the biodiversity value of a site. The biodiversity gain objective is met if the biodiversity value attributable to the development exceeds the pre-development biodiversity value of the on-site habitat by at least 10%. Developers in England will be required to deliver the 10% biodiversity net gain from January 2024 onwards. A developer would need to employ a qualified ecologist to conduct a survey of the development land and complete the metric. The data will then be provided to the local planning authority as part of the developer's biodiversity gain plan. A simpler, small sites metric has been designed for small sites, but the implementation of this has been pushed back to April 2024. If you are buying land conditional on planning, you may want to consider incorporating biodiversity net gain requirements into the contract. For example, to ensure that you will be able to discharge the biodiversity conditions satisfactorily before completion. Also, you may wish to consider opportunities for a seller to provide off-site biodiversity net gain if there is retained land. Developers are encouraged to follow a hierarchy of mitigation measures to avoid, minimise, restore and offset impacts to biodiversity. Avoiding or minimising impacts to biodiversity should be prioritised. In some cases, it may be challenging to achieve net gain on the development site itself. Biodiversity offsetting enables developers to impair the habitat value of a site, provided they pay to restore another habitat site that has the potential to become at least the same quality as the habitat that will be lost. Developers can meet the biodiversity requirement through off-site biodiversity habitat creation if the developer has access to additional land. A system to generate and trade biodiversity units is proposed for situations where the developer does not have access to additional land. These units or credits so acquired will be linked to other biodiversity sites managed and maintained by third parties that will in turn allow the developer to fulfil their enhanced biodiversity requirement without actually providing the habitat on their development site. Significant increases in on-site biodiversity value can only be considered by the local planning authority as part of the post-development biodiversity value if they are secured through a suitable mechanism such as the planning condition or Section 106 agreement, and will be maintained for at least 30 years after the completion of the development. In order to secure off-site gain, the Biodiversity Gain Site Register is used. The core purpose of the register is to record allocations of off-site biodiversity gains to developments and make this information publicly available. Biodiversity gain sites are sites that are bound by a planning obligation or conservation covenant which requires habitat enhancement works to be carried out on the land and maintained for at least 30 years following completion. The Environment Act introduces conservation covenants. These are voluntary legal agreements which bind current and future landowners to positive and restrictive conservation-related actions for a minimum of 30 years. The agreements are enforceable by responsible bodies. Whilst conservation covenants came into effect in England in September 2022, we've been waiting for guidance to confirm which organisations can apply to become a responsible body. Given the complex legal nature of these documents, there is a need for extensive due diligence before entering into them. So to conclude, it is vital that developers consider biodiversity net gain from the outset for any planning development. Planning applications should be supported by a biodiversity gain plan complete with the biodiversity metric calculations. The biodiversity plan should outline how net gain in biodiversity will be achieved and managed for a minimum of 30 years after development, and how this will be secured, whether by a planning condition or planning obligation. Developers should use this time to familiarise themselves with the guidance and prepare for the integration of biodiversity net gain into the planning system.
Thanks, Emily. It'll be interesting to see if things do progress as per this new timetable. So now I'd just like to pass over to Laura, who's going to take us through the case law update.
So good morning everyone, and thanks for joining us today. So this morning I'm going to take you on a whistle-stop tour of some of the most recent case law that may be of interest to you. We'll start with renewal leases and the case of BMW UK Limited and K Group Holdings Limited. This is a decision of the Central London County Court, which, because it's a county court decision, does not set a legal precedent. However, I've included it within this update because it gives a useful indication as to how district judges approach these matters. So in this case, BMW was seeking renewal of 4 leases that were occupied together as one showroom on Park Lane in London. The landlord did not oppose the renewal and were negotiating the terms of the new leases, but there were 2 terms the parties could not reach agreement on. Firstly, whether there should be a landlord break option, and secondly, the rent for each lease. The landlord in this case was seeking a right to determine the new leases at any time on 6 months' notice between the 2nd and 5th anniversaries of the term commencement, together with obligations to reinstate one of the units as a separate self-contained unit. The judge expressed that it was important in these types of matters to strike a balance between the interests of both the landlord and the tenant. The tenant needs a degree of security of tenure, and the landlord should not be deprived of future opportunities to redevelop or secure occupation for its own use. In this case, the landlord wanted to take back the property for its own occupation and would be relying upon Section 31G of the Landlord and Tenant Act 1954. The landlord had evidence that it was exploring the sale of converted classic cars from the property, but that the plans were in their infancy. The judge queried whether, on the balance of probabilities, the landlord's intention was sufficiently on the cards or genuine and workable. The judge came to the conclusion it was not, and that the evidence demonstrated by the landlord was vague and unsupported. Therefore, the request for the break clause was rejected. In relation to the rent, the parties were some way apart, with the tenant being at £76 to £100 per square foot and the landlord at around £228 per square foot. It was relevant in this matter that the tenant occupied adjoining premises, and the judge stated that where the tenant occupies adjoining premises, the rental effect on the subject premises has to be taken into account. Section 34 of the Landlord and Tenant Act 1954 requires a valuation that disregards the occupation of subject premises, but it does not disregard occupation of adjoining premises. In respect of each lease, BMW was an adjoining owner, and this had to be reflected in an open market valuation. The judge held the value was part of the open market bargaining between a willing landlord and tenant, and no uplift needed to be added. Based on the comparable evidence, the judge settled the rent at £126 per square foot. The takeaway point from this decision is that if landlords are seeking to include a break provision within a lease renewal, that they need to ensure the evidence is well set out. Although the plans do not need to be complete, the landlord does need to demonstrate that they have well thought through plans that are workable, and there's a real possibility the break will be exercised. Now, there have been a number of cases recently where the landlord has sought flexibility on a lease renewal, and in the case of B&M Retail Limited and HSBC Bank Pension Trust UK Limited, B&M was the tenant at a premises in London. The landlord served a hostile Section 25 notice, citing Ground F, the redevelopment ground, as its reason for opposing the lease renewal. The landlord had entered into an agreement for lease with Aldi for the grant of a new store that was to be built on the site. Now, that agreement was conditional upon planning permission being granted and the landlord obtaining possession of the site by February 2025. The Section 25 notice that the landlord served was ineffective because B&M had already served a Section 26 notice requesting a renewal lease in January 2021. The landlord had not taken action upon receipt of the Section 26 notice and did not serve a counter notice opposing the lease renewal within the relevant timeframe. Therefore, B&M was entitled to a new lease. The court in this case was asked to determine the term of the new lease and whether a redevelopment break clause should be included. The tenant sought a new 10-year lease without a break. The landlord was seeking an 18-month term with a rolling right to break for redevelopment purposes on 6 months' notice. When considering the request for a break right, the judge reviewed the authorities and stated that a court will only upset a landlord's redevelopment ambitions if there is a major factor which points the other way, and whilst the claimant is correct in that a balancing exercise has to be undertaken, if anything, it is trumped if a landlord wishes to redevelop. The judge assessed the evidence and concluded that there was sufficient evidence to indicate that the landlord would be successful at planning, and there was no reason to frustrate the landlord's proposed redevelopment. The judge stated, if the new lease did not contain a break clause, there would be substantial prejudice caused to the defendant's redevelopment plans, with the potential that the advantageous terms of a lease with Aldi will be lost. The judge allowed a break provision to be inserted, allowing redevelopment operable immediately. The judge also allowed a term of 5 years. Now, this is once again a county court decision, so it does not create legal precedent, but it shows how judges are considering these matters. Now, one of the most talked about cases of the year is the matter of Fern and Others and Board of Trustees of the Tate Gallery, which discusses common law private nuisance. A common law private nuisance is where land is being used in a way that wrongfully interferes with the ordinary use and enjoyment of a neighbouring land. To bring a claim, there must be a substantial interference which is judged by the standards of the ordinary person. Even if there is a substantial interference, and the party using the land will not be liable if they're doing no more than making a common and ordinary use of the land, which is assessed by having regard to the character of the locality. The facts of this case are that in 2016, the Tate Modern Art Gallery in London opened a 10-storey extension that had a public viewing platform giving panoramic views of the area. The platform was open daily and could have up to 300 visitors at once. 30 metres from the platform, there were flats that form part of the Neo-Bankside development. The flats themselves had wall-to-ceiling windows and winter gardens. The visitors to the Tate Modern viewing platform had a direct view into the living areas of the flats. The owners of the flats brought a claim in nuisance seeking an injunction to close the relevant part of the gallery, or in the alternative, damages. They also brought a claim under the Human Rights Act to protect their rights of privacy. The High Court dismissed their claim, and so they appealed, and the Court of Appeal also dismissed their appeals. However, on 1st of February 2023, the Supreme Court allowed the appeal and found that the Tate Modern had caused a private nuisance. The court found that the living areas of the flats were under constant observation by those visiting the platform. That, coupled with the photos the visitors were taking, amounted to a substantial interference with their ordinary use and enjoyment of the land. While some developers may be concerned by this decision, the court did emphasise that it would be quite rare for visual intrusion to be of sufficient duration and intensity for it to be actionable. Now, the final case I'm going to deal with today is the matter of Great Jackson Street Estates Limited and Manchester City Council, which was a matter dealt with by the upper tribunal. In this case, a developer applied under Section 84 of the Law of Property Act 1925 to modify various leasehold covenants of a development site. The development site is located at Great Jackson Street in Manchester City Centre, and the landlord of the site is Manchester City Council, and the tenant has a leasehold interest of 2 warehouses that they want to redevelop into a residential flat scheme, which would contain 2 56-storey tower blocks that would contain 1,037 apartments. The tenant obtained planning permission from Manchester City Council in its role as planning authority for the site in 2021. However, the developer could not carry out the development without the consent of Manchester City Council in its capacity as landlord due to various covenants in the lease relating to alterations and use. One of the covenants prevented the use of the buildings on the site other than as light industrial buildings or wholesale warehouses. There was also a covenant preventing the tenant from making additions, alterations or improvements to the existing warehouses or erecting any other buildings without the consent of the landlord. The tenant also could not sublet or part with the possession of the whole or part of the premises without the consent of the landlord. Now, Manchester City Council were unwilling to consent, so the developer applied to the upper tribunal to modify the covenants. The upper tribunal found as follows. Firstly, the restrictions had not been demonstrated to be obsolete due to changes in the character of the neighbourhood. Whilst the character of the neighbourhood had changed, the covenants were not obsolete because Manchester City Council had a legitimate interest in retaining control over the use of the land and ensuring that development in the area was carried out with appropriate safeguards. Secondly, the covenants did impede a reasonable use of the site, but the covenants continued to secure a substantial benefit for the council by allowing the council to control the development of the site and ensure it was delivered in a timely manner. And finally, the upper tribunal also found that injury would be caused to the council by modifying the restrictions, as it would lose control over the redevelopment of the site. Now, this case is of interest because it shows the council wearing 2 different hats. One as a local planning authority, where it did not object to the development, and one as a landlord, where it wanted to retain control over the development. In this case, the upper tribunal was satisfied that the covenants were being used for the purpose on which they were intended. Now, that brings me to the end of my update on the recent case law, and thank you very much for listening.
Thanks, Laura. So as promised, I just want to talk for a moment or two about property insolvency in 2023. If you watched our seminar a few months ago, you'll remember that we talked quite a bit about tenant insolvency and its effect on the landlord. But I thought it was worth touching again, as retail and hospitality and leisure in particular continue to be badly hit by energy costs and the cost of living. Wilko is the most high-profile insolvency in recent months after it was placed into administration due to a failure to find a rescue deal. I thought it would be useful to look at Wilko as a bit of a case study about the process of administration and how it can affect a landlord. So it's been reported that the administrators have announced a deal has been done with Poundland's owner, Pepco, giving Poundland the potential to take control of up to 71 Wilko store leases. Then there's also a deal with B&M to take up to 51 of these stores. So what does that mean if you're a landlord of one of the stores which has been offered to Poundland or B&M? When a company is in administration, there are a number of restrictions on what the landlord can do. The main one being that a landlord can't take enforcement action without either the leave of the court or the consent of the administrator. So often in circumstances like we have with Wilko, the administrators will allow a purchaser of the business or assets of the company into immediate occupation of the premises without the landlord's consent. This doesn't, however, negate the need for the proposed new tenant to obtain the consent to the assignment of the lease, assuming the lease requires this, which obviously most of them will do. So landlords of insolvent tenants don't have to automatically agree to take on a new tenant. The terms of the lease do still apply to the application for licence to assign, and so the landlord can still insist on any conditions in the lease being satisfied. So, for example, an incoming tenant providing a rent deposit or a director's guarantee, and proving that the tenant is of sufficient covenant strength to allow it to comply with the terms of the lease. The need for the landlord's consent to a lease assignment usually leads to the administrators granting a licence to the incoming purchaser to occupy the new premises. As said, this is usually in breach of the lease, and even if a landlord ultimately consents to an assignment to the purchaser, I'd advise them to make it clear to the tenant's representatives that they have not consented to the occupation by the purchaser, and that they reserve the right to take action to remove them from the premises. A landlord will usually rank as an unsecured creditor in relation to any unpaid rent that fell due before the commencement of the formal insolvency, and often makes no recovery or a limited recovery of those sums. However, if the property is being used for the purposes of the administration, the landlord is entitled to recover rent from the date of commencement of the formal insolvency as an expense of the administration. Expenses of the administration are paid before even the fees of the administrators, so they are very well protected. The licence will normally require the purchaser to pay a licence fee equivalent to the rent to the administrator for onward transmission to the landlord. And the fact the rent will be payable as an expense is a very good incentive for the administrators to make sure that the licence fee is in fact collected and on time. The licence will often also provide that if the fee isn't paid immediately when it's due, or if the landlord objects to the occupation of the licensee, then the administrators have the ability to immediately terminate the licence and require the purchaser to leave the property. So in any case, landlords are advised to make it clear when accepting payments, especially if the purchaser proposes to pay directly, which we wouldn't advise, by the way, that the insolvent company will remain as the tenant until any assignment, and that any payment is being accepted as having been made as agent on behalf of the tenant. So ultimately, the landlord must decide whether to consent to any assignment that's proposed. In the current climate, and particularly where strong brands like Poundland and B&M are involved, it's likely that the landlord would be well advised to consent to the assignment. In other similar circumstances, even if they do have doubts about a purchaser's ability to pay the rent for the remainder of the lease term, retail landlords in particular might still be better off consenting to the assignment to maintain a short-term income stream, rather than risking an extended period with a vacant unit, during which responsibility for business rates could revert to the landlord and repairs and so on. If consent isn't given, the administrators would have the option of applying to court for a declaration that consent has been unreasonably withheld or delayed, or simply proceeding with the assignment on the basis that consent has been unreasonably withheld. An application to court would probably require the incoming tenants to agree to pay the costs of the administrator making the application, and so really it would depend on how valuable the property was in the context of the overall portfolio. The administrators could try and argue that the assignment should be allowed because it's in the best interests of the creditors of the insolvent company. But this will also often depend on whether there's a contingent consideration due to the company as a result of the assignment taking place. So if the administrators have already had all the money they're going to get, it's hard to see what the advantage to the creditors of the insolvent company would be. This is a really complex area, and we'd strongly suggest that as soon as you have any hint of your tenant becoming insolvent, you give us a call. We can look at the whole picture for you and advise on the best strategy for the particular circumstances. Almost every day at the moment, there are announcements about companies entering into administration or liquidation due to difficult trading conditions. Outside of the formal insolvency arena, there are a number of large retailers announcing waves of store closures. So Boots have just announced that 300 stores are set to close, with the first wave shutting in a matter of weeks. And Next and M&S have also announced shutdowns amid difficult trading conditions this year. it seems that the fallout from the difficult economy is likely to continue for some time, as I said at the start of the webinar. So now finally, we come to our property portal. If you haven't already seen it, this is our fantastic new platform which we've developed to assist our clients and also our property professional contacts. It gives you access to a whole range of property information and resources and services that will all help you keep up to date and connected to what's going on in the property world. It can also help you massively with the day-to-day business of managing your portfolio. This is because we've got a specific platform embedded in the portal where you can store all of your property-related documents. So your titles, occupational leases, but also any licenses for alterations, EPCs, asbestos surveys, anything that will make your life easier that you might need to get at a moment's notice, save you trawling through your emails to find a copy of a document. We can also cater for clients who hold properties in multiple entities. We can put everything together on one platform for you and also grant access to whichever members of your team you would like to have access so that they can keep up to date with everything that's going on. The platform is completely free to use for both property professionals and clients, so please do sign up and have a look around. Once you're in the portal, you'll see lots of useful documents on various topics. There's things like checklists, flowcharts for common situations you may find yourself in, and also links to other useful websites. We also have sections for news, where you can find our relevant blogs and other content, and there are also guides on various topics to help you. There are then links to videos and webinars like this one, so you can watch those again. You'll also be given exclusive early access to invitations to our events and webinars. So as I said, please do sign up and have a look. The content will develop further over time, and we're very much open to feedback and suggestions as to what you'd like to see in there. So that's about all we have time for today. If you do have any questions you'd like to run past the team about any of the topics covered or anything else you'd like to have a chat about, please don't hesitate to get in touch with us. Thanks very much for joining us, and goodbye for now.